Hello everyone. Last week, the EB-5 Reform and Integrity Act of 2022 was passed by Congress. There have been a lot of changes related to EB-5 rules in the past, but this law change is a big deal because this is the first time the law is changing since 1993. All the other changes that we've seen related to EB-5 throughout the years were mainly regulatory changes or changes in the USCIS policy guidance. But this time the law itself has changed. Today, I wanted to make a quick video about 3 things that are really relevant to new investors. First is the minimum investment amount change. The minimum investment amount for EB-5 used to be $500,000, it went up to $900,000, and there was litigation, it was brought back down to $500,000, and there's been so much noise related to EB-5 minimum investment in the past few years. Bottom line is now it is $800,000 for TEA, Targeted Employment Area projects, and $1.05 million for non-TEA area located projects. This number will stay the same for at least the next 5 years, and after that there will be adjustments made based on the Consumer Price Index. The second important change brought about by this new legislation is that now concurrent filing is possible with EB-5. In other words, if you are already in the United States on a valid non-immigrant visa, that means you can file your EB-5 petition concurrently with an adjustment of status application, also known as an I-485. This was not possible in the past. Until now, even if you were in the United States, you could not file for an adjustment of status until after the I-526 was approved. I-526 approvals, until recently, were taking 2 years. But I-526s were not being adjudicated for the past 9 months because the EB-5 program had lapsed. And before the lapse of the EB-5 program on July 1st, 2021, we had COVID really slowing down adjudications. And before COVID, we had the Trump administration artificially depressing the number of approvals. So there is a huge backlog in I-526 adjudications, and new I-526s could take upwards of 3 years or more. So the fact that you're able to file an adjustment of status together with your I-526 is a pretty big deal if you're thinking about EB-5 and you're already in the United States. Because this means that you'll be able to get a combo card, meaning your EAD or work permit and travel documents to travel overseas while your I-526 is pending. The employment authorization and advanced parole, also known as your work permit and your travel permit, will probably take at least 6 months to get approved. There have been some backlogs with EAD issuances, and there's been litigation because people were not getting their EAD for upwards of a year or more. So I'm not exactly sure how long it's going to take now that EB-5 is back online, but it won't be 3 months like it used to be a few years ago. This means once you file your I-526 and your adjustment of status, or I-485, concurrently, you won't be able to travel for about 6 months or until your travel card is approved. So while that is an inconvenience, the fact that you can do concurrent filing with your I-526 is a pretty big deal if you're running out of status as a student or you're on an H-1B and you want to start your own business. But here's one very important thing about concurrent filing. Not everyone can do it. You can only do concurrent filing for a certain category, even if it's allowed, if the visa numbers for the country that you were born in is not backlogged, or in other words, is current. Without going through a long explanation of what that means, I can just tell you that as of March 2022, the 2 countries that have backlogged EB-5 numbers, in other words, where EB-5 is not current, is China and Vietnam. Another big change of the legislation of 2022 is that it now protects people who have invested and filed I-526s in the case of future lapses of the Regional Center program. As I mentioned before, the Regional Center program had lapsed for the past 9 months. While the industry knew that it would be coming back online, it had never lapsed for such an extended period before, and this made a lot of people nervous. In addition to that, the USCIS wasn't processing any I-526s or 485s related to I-526s, which really delayed the process for many people. Now, the law provides for grandfathering. So if in the future, after 5 years that we have another reauthorization lapse, that people who are in the pipeline no longer have to be concerned. Even though the minimum investment amount has gone up to $800,000 from the previous $500,000, I believe the opening of concurrent filing will have a big impact on revitalizing the EB-5 market. As a result, many regional centers, like ourselves, who have not been actively promoting projects in the past couple of years due to the myriad of uncertainties, are now going to be coming back online with new projects, which means there will be more opportunities for future investors interested in EB-5. In addition to these 3 changes, the new law also sets out a lot of new rules related to regulating existing regional centers. I'll be doing a quick video on those changes in the future. Thank you very much.